A warm good morning to all the dignitaries present, and thank you, Sampath sir, for this wonderful opportunity. I would like to begin with the words of Justice Benjamin Cardo, the Judge of Supreme Court of USA. New times demand new measures and new men. The world advances and in time outgrows. With the advancement of technology, there was a new beginning in many fields, including dispute resolution system. The tremendous progress made by the computer technology during the last quarter of the 20th century. It has made it possible for the people to visually chat, send message, transmit information, and conduct business with person in any part of the world through internet. To address the issue and obstacles arising out of electronic medium, the United Nations Commission on International Trade Law formulated the model legislation on electronic commerce. Here I would like to pause. Before we get into my topic of judicial administration and functions of virtual court, it is very pertinent for us to understand from where we have got this. The history is very, very important. So that is why I'm just taking it from the ancestral model. Okay. The corresponding, the first initiative was the United Nations Commission on International Trade Law formulated a model legislation on electronic commerce. Corresponding to that, then ancestral law, the on Electronic Commerce Act was passed in 1998. Then Electronic Commerce Support Act was passed in 1998. In the later date, after the upgradation, the Information Technology Act came into force in 2000 by the Government of India. It was a central act, and it is also based on the model law of the UNCTAD. The object of the Information Technology Act was as defined therein as under, to quote, to provide a legal recognition for transaction carried out by means of electronic data interchange and other means of electronic communications, commonly referred to as electronic methods of communication, storage of information, to facilitate electronic filing of documents with the government agencies, and further to amend the Indian Penal Code, Indian Evidence Act 1872, the Bankers Book Evidence Act 1891, and the Reserve Bank Act 1934, and for the matters connected therewith and incidental thereto. This is what is the objective of the Information Technology Act that came into force. By the enactment of Information Technology Act, the E-Code project, the Supreme Court brought about an E-Code project. That is, the E-Code project integrated the mission mode project was produced as a product of national e-governance of high courts, district courts, and subordinate courts. So this is a byproduct of the Information Technology Act. The project was convened on the basis of the National Policy and Action Plan for Implementation of Information Communication Technology, ICT, in the Indian judiciary in 2005. By the E-Committee of Supreme Court of India with a vision to transform Indian judiciary and enabling the courts to implement information and communication technology, that is ICT. The project is being implemented by the NIC, that is the National Informatics Center. The initiative aimed at providing coherent and efficient service delivery to the people of India, complying with the E-Codes project and to the litigant charter. It also facilitated, developed and implicative and supportive systems in court to provide a transparent and accessible system for information to all its stakeholders. This is very, very, very important aspect of it. The judiciary needs to be transparent and it needs to be accessible to all stakeholders. That is the basis of the judiciary. The trust lies here. The next objective was to improvise the judicial system to deliver justice to the concerned litigants with the utmost convenience in cost, time, and reliability. The e-court systems came up in two phases. The first phase, the initial things of bringing in the hardware and the software, and the judicial service system that is was established to computerize everything, and the case management system was brought in, wherein the computers, the way, the methodology, the how we take in the programming, how we manage the cases in courts and all these things were the court staff were trained with this new technology, that is CIS. And after that, there was the process of re-engineering. After doing this, they went into the next level of helping them to study this and suggest more rules and how procedures, forms, bring in, and all these things came up. The next step was this, the video conferencing facilities in courts, in jails. That's in prisons. As a video conferencing pilot project was launched in 5 districts under supervision of E-Committee. Based on the pilot project, the VC is rolling out in remaining all locations throughout the countries in phase 1. So that is very, very interesting thing, because even during the COVID times, we were able to run the courts. The judiciary was able to do a lot of work, and justice was upheld. So that is the wonderful aspect there. Then the next comes is the service delivery and national judicial data grid. The national e-courts portal that becomes operational. The National Judicial Data Grid has the entire data about what are the number of cases, what are the cases, and which court it has been there, the parties, the names of the parties, the kind of the cases, how many cases it has, and how much has been resolved, and how much has been spending, and everything is there in the National Judicial Data Grid. But it can be accessed by anybody. It's there in the web portal, and you can, in the e-courts website, anybody can access that and see the present pending cases or the cases that has been disposed of. The portal also provides online service to litigants, such as litigants and lawyers, as for the case registration, the cost list which is being provided by that, and the case status of the pending cases, and the daily orders that has been seen there. Not usually earlier days, before the technology came in, we as juniors, we used to go to the courts and look at the court diary. We would wait for the BC to give us the diaries, and so that we can note down what has been written there, and when we would wait for the BCs to give us the bundles to find out what there was a day, whether there was a daily orders. Now it has become very easy. They can just, with the click of a button, they will know what is the daily orders of that particular case, and even the final judgments. The progress in this part is that now because of the upgradation of the mobile numbers, the advocates registration, all the advocates are required to register their numbers, mobile numbers and email IDs with the court which they are predominantly practicing. Okay, in case they practice, they will be sent their messages on their mobile phones and emails of when they file a case, and when it is numbered, and when the case has been taken up for hearing. And if they file a copy application, that application also with the SR number will be given to that number. If they're going to get a final judgment, the judgment copy, they will get a message saying the judgment copy is ready. So you don't have to go every time to the section to find out personally whether the copy is ready or not, and whether you have to bombard your junior or your clerk to get it done. No, it's very simple. It happens automatically, because there is a list of program that has to be done by the people, and it is being followed. Currently, the National Judicial Data Grid also helps the judiciary in judicial monitoring and management of the e-governance. Okay, so the High Court, as you all know very well, the High Court monitors and administers the lower judiciary, the district courts and subordinate courts. and the Supreme Court has its own monitoring system over the high courts. So they can easily access 24/7 about all the cases and what's happening in that court and how it is going on. Everything can be accessed by this new facility. In phase two, the infrastructure was strengthened, and another initiative was done was that serving of the notices and summons were done by mobile apps. Okay, so that's a new thing called N step that will be delivered by the bailiff through the court by the mobile apps. That's a wonderful system which goes with the geo positioning and the credentials. So there cannot be any impersonation, or they cannot be anything saying like, I did not receive it, they did not come, the position was not there. So all those excuses cannot be given there. It will clearly say and mark, the bailiff can mark himself saying that he was present at the place, the person was there, and the everything geo positioning will be recorded. It cannot be corrected. And the option of desktops and laptop options were also given. So even now, most of the advocates who are unable to access their laptops or desktops, they just log into their courts in a hurried time through their mobile phones. So that is also an advanced version, adapting the technology to the mobiles or tablets. So Apple pads or iPads or whatever it is. So that technology transformation of this program that can be delivered in different gadgets also. And the hardware and district legal service authorities and taluks legal services committees were also upgraded. So the next thing is after upgrading all this, we also thought people should be independent without asking anybody. They should be not dependent on a person to just get some information. So they should be easily accessing the information even without a gadget owning a gadget by themselves. So that is why the computer kiosks were installed in court complexes, where when the litigant or the advocates, they can just go there and just the touch screen, they can use the touch screen and get the information about their cases, pending cases, filed cases, judgments, everything can be accessed there. Then the next important factor came up with the development of central filing system. This is the CNR number. Then by the e-filing was made compulsory. Even now the court has said like we have to do an e-filing. Before we slowly they are making us accustomed to the e-filing, and finally we will be there will be a day that everything will be done only by e-filing. So we have to get ourselves upgraded every time. So when we do an e-filing, suppose you file a plaint, there is a 9 steps to complete all this. When you do this, you get a CNR number. That's a unique number. Okay, this unique number is with any filing you get this number. So this is a central number. The number will denote which place which court it is being filed, what kind of a case it is, and when then a particular district and the particular special number for the case. So there cannot be 2 CNR numbers for any 2 filing. So you can easily identify the file by the CNR number. Then there is another important aspect is that if you go on after filing your plaint, you want to do some additional documents, or you want to file an written arguments. Even then you can file an e-filing, and then there also that filing number will be given a CNR number. So you can track that CNR number to find out whether that number has been, that document has been given a number, SR number, and or a document number that has to be kept, or MPs that is being filed, that number will be there. You can track using this CNR number. Then there was other aspect was the computerization of libraries, and most important aspect is the video conferencing of all courtrooms, right? That was the upgradation. So this upgradation was very, very important, and it was very successfully done during this COVID. COVID had a positive effect in as far as the judiciary is concerned. We had taken up lot of initiative and a lot of success has come down because we are able to access it, and there was no other choice. We had to access it. So we took it as a mandatory thing and we completed it. Okay. So with all these things revamping, we needed a cloud computing to take up everything, store it everything in the cloud. It cannot be done in a server. So like this, there was a several remarkable changes in the administration of uh, administration and functioning of the virtual courts. So coming to this, the E-committee resolution on the 10th and 11th of January 2020 in Supreme Court, it was started. And here e-filing enabled in High Court of Madras from 22/4/2020. And e-filing in High Court, in district courts were started in 22 May 2020. So the major project here is this mobile app, e-court portals, High Court services, payments, the virtual courts, the national data grid, touchscreens, kiosks, the e-seva kendra, and the filings. Now moving on to the next one is the virtual court. Virtual court is not a concept aimed at eliminating the presence of a litigant or a lawyer in the court. And it is only for the adjudication of cases on a virtual platform. Many were against this, bringing up this virtual court, and they wanted only physical presence. Physical presence in court and arguments in the court is a pleasure for everyone. For any lawyer, it is the maximum pleasure that they can get in a profession is to be physically present in a court. But in times of calamity, but in times of necessity, we need to adapt the technology. The concept has been evolved in order to facilitate efficiently and utilize the court source resources and to provide the litigants effective avenue to settle petty disputes. The first initial thing that we tried was the mobile app. Using the mobile app, we did the motor accident cases, that is traffic violation cases, that was taken up in the mobile courts, and those was done through mobile phones, and even that can be done asynchronous method, right? The offenses under Motor Vehicles Act, the traffic challan cases, right? Through this mode, sir, I will be just finishing it off in just 3 more minutes.
Yes, because of time. Okay. Time management. Okay.
Yes, sir. Petty offenses cases also were under section 208 were also done. The parties will be intimated through their mobile phones, and their challans summons will also be served to them through their mobile phones, and the parties at leisure, they can log into their challans and pay the fine if they feel that they want to pay the fine. If they want to contest the case, they can very well come to the court and do. But in case they don't want to contest the case, they can pay the fine through the mobile courts and they can finish it. Next case was the online, the basic difference between the virtual court and online court, right? The virtual court is that where we file our, we can file the wakalat documents, everything that is being done. That has to be done in an with the former, the people have to be present there. The person has to be there. He has to be doing it at the same time. Okay. But online court is that it's an asynchronous system, but you don't have to be there. It's like the mobile payment of money or anything, challans or all these things. Okay. That is, you don't need to be available at that time of the case when the case is in progress. So online courts need not be, parties need not be simultaneously present. They can present their arguments or payment of anything or evidence can be done, recorded and send it to the courts, which can be done. So that is the difference between virtual court and online court. Okay. And the last thing about online dispute resolution. Online dispute resolution refers to the platform of dispute resolution through mediation, conciliation, and arbitration. The only Tamil Nadu Mediation Conciliation Center was the first center in India to start the online mediations and the online mediation training in the country. So we are the leading person in online mediation training. And the Maharashtra Legal Service Authority, they have created a wonderful landmark initiative, that is that they have created a toll-free call center numbers, wherein somebody calls 100. Here in Tamil Nadu, the police department will pick it up. But in Maharashtra, they have, when you call the 100, that will be directed to a call center. And the call center, the people will analyze whether this goes to the court or this goes to the police station or to the counseling center or mediation center, and they will direct the parties to that platform. So that is another initiative that has come up for the better online dispute resolution. The only thing I just want people here who are present here to understand in virtual court is that remember that we are all humans, and the person who are there with you in the court is also a human. So we like to see everybody their full face before we argue. Most of us forget our our virtual presence in the virtual platform. Either we come too close to the screen or we go
please,
too back to the screen.
Time, please, because
yes,
after 45 minutes,
yes, sir.
Speakers there.
So
Okay.
Please know your cyber space and respect the people who are there in the platform with you. So give them also the credit. So with that, I conclude this, and I thank Sampath sir for this wonderful opportunity. Thank you, sir.